Hey everybody, Sean Bukowski here. Hope everybody had a great holiday weekend as we celebrated the American labor movement and sort of the contributions that labor has provided to the development of the United States. So hopefully that was a good weekend for everybody. This week we're going to talk about purchase agreements again, and I've done that a little bit lately. We've talked about commercial purchase agreements because for two reasons. We do a lot of work in Texas, and in Texas, there are a lot of promulgated forms that people use, and either they draft them themselves or they rely on their broker to draft them. And so that's something that, it can be very good, but we've written about it before. We don't always love those forms, and sometimes it kind of gives buyers or sellers a sort of false sense of security because there's things that need to go into those forms that aren't in them. And as a result, we're kind of talking a lot about purchase agreements so that if you listen to what or read about what we talk about, you'll understand the different provisions a little bit better and maybe get some tips about how to make those provisions work for you more, and you'll be in a better position in case something bad happens. So we are talking about purchase agreements this week, specifically a little bit about escrow deposits. The basics of escrow. I think most people know the sort of basics of escrow, at least if you've been in this area before. But you put down a certain amount of money. That amount can vary depending on the parties. We sometimes we'll look at 10% of the purchase price or somewhere in that range, depending on how big. If it's $100 million, it might not be that big. But we'll look at some sort of deposit. You make the deposit with the title company, and they hold it. And generally, there's provisions in the agreement where during the due diligence period, the buyer can terminate the agreement for any reason and get a refund of all, or at least most of that escrow deposit. And what the escrow deposit does is it shows that the buyer's serious. You put down a certain amount of money, that's a commitment. It's a commitment to the seller that you're going to purchase that property. So that's kind of the basics of escrow deposits. Now, in the recent years, look, Texas market's on fire, right? We all know that. It's the commercial real estate market in Texas is on fire. It's a great place to invest, residential also, but we're focused on commercial. And so as a result, it's really a seller's market, and the sellers have been able to demand certain things from buyers. And one of those is partial or all of the escrow deposit is non-refundable. We represent buyers a lot, and that's often a sort of tough pill to swallow for buyers. So we generally try to push back on that, make that escrow deposit refundable, because what happens is you don't get a chance to do due diligence during the purchase period. With a refundable deposit. And so if something comes up during due diligence that really hurts the project, you're not going to be able to get that escrow deposit back. So yes, we always push back on that if it comes up. I understand. Eventually it's a business decision. You have to make that decision, and sometimes to chase these properties, you might have to put down a non-refundable deposit. Just make sure that you do as much due diligence as you can before you sign that up. So I understand that can happen sometimes. One thing that I've heard about, I haven't seen yet, but I've heard about, are sellers pushing because for the title issues to be non-refundable also. So if you've done this, you probably know that another way you can get your escrow deposit back generally is if there's a defect in title, and that comes from the title company title commitment. That is not cleared prior to closing. That's always been something where you can get your escrow deposit back if you terminate because of a defect in title. Because it's such a strong seller's market, I've heard of sellers pushing to get buyers to waive that provision also. This is something that we are dead set against. I would very strongly tell a client not to sign a waiver of the title provisions, because if there's a defect in title, that's really difficult to fix, and it's a real problem for the buyer. And as a result, the only way I would say, okay, you can sign that, is if you're willing to walk away from that escrow deposit entirely, because you might have to if you sign that. So, there's been some changes lately in escrow deposits. We talked about what the general overall sort of basics are, but there's been changes. I think these changes, if there's going to be changes, you need to run them by your lawyer. And obviously here at Bukowski Law Firm, we're willing to help you do that. I hope you enjoyed this. Please sign up or follow us on YouTube, be a subscriber on YouTube, and read our blog. Thanks a lot. Have a good one.